Can I just mention that one matter we've been discussing over the adjournment is what exactly is meant by deboning, and we're not quite clear about that. So if you want to address that at some point, that'd be helpful.
I shall be addressing that. Can I start though with what did the Court of Justice decide in this case? Can I ask you to turn to the decision of the Court of Justice, which begins at MS 1417, and I'm going to refer to paragraph numbers in the judgment. One thing that is clear is that the Court of Justice decided the questions which were actually referred to it by the judge against Newby and against the UK government. The questions are summarised in paragraph 40 of the judgment of the Court of Justice, and as the Court will recall, they essentially focused on whether it was necessary to fall within the category of MSM that there was a significant loss or modification of the muscle fibre structure. The questions are summarised in paragraph 40. The background and the important bit of background to the questions is summarised in paragraph 34, which is the finding of the referring court that Newby's products did undergo a modification of the muscle fibre structure. And the questions summarised in paragraph 40 are answered in paragraph 41, and in particular in the final sentence of paragraph 41, beginning in particular, the definition of MSM does not make any distinction as regards the degree of loss or modification of the muscle fibre structure, with the result that any loss or modification is taken into consideration within the definition. So, questions asked decided against Newby and the UK. In paragraph 42, though, as you have seen, the Court of Justice goes on to introduce the what the parties have been referring to as the cutting point qualification. Consequently, any meat product which satisfies those three criteria must be classified as MSM, irrespective of degree of loss or modification of the muscle fibre structure, insofar as, and that's perhaps a significant word in this particular paragraph, insofar as by reason of the process used, that loss or modification is greater than that which is strictly confined to the cutting point. So this is a test which is intended to apply to any meat product, not just the Newby products, but it's a statement of more general principle.
When you look at the first criterion in paragraph 41, it looks as though, well, the court is treating boning as the detachment of the intact muscles.
Yes, and that was. I mean, what? I mean, let me address this now. What I was going to say as to the definition of boning is, first of all, the judge and the parties at the stage of the High Court, at least, thought that it was obvious what it meant. Secondly, the meaning of boning has never given rise to any difficulty in these proceedings. But thirdly, if you wish for a more expansive definition of that, the best that we can do is really the paraphrase of the Court of Justice in paragraph 41. And if you compare the first criterion in 41, as described by the Court of Justice in 41, with the legislation, then the word or the phrase after boning has been substituted with from which the intact muscles have already been detached.
And what do you say they mean by intact muscles? For which the French is muscle entier.
Yes. Well, it's certainly intended to convey entire or whole. There's reference elsewhere in the judgment to the main part of the meat being removed, and in practice, and the reason why nobody thought to question the meaning of the term until quite recently, it's well appreciated that the initial stage of removing the meat, and whether you call it the prime cuts or the main part or whatever, is boning, and what Newby uses is what's left after boning.
Although we know it may be, clearly from the evidence, there's a lot of meat still there.
There can be, yes, there can be a significant amount of meat.
So it's not as though the entirety of the musculature of the animal has been taken off the bone.
Well, my lord,
Can't be,
it's not.
because otherwise there wouldn't be any meat to separate.
Yeah.
Yes, it can't be the entirety of the meat. It's the main muscles, the main part of the meat, the entire muscles. Lord, I can't.
So the entire muscles can't mean the entirety of the muscles.
Can't mean all of.
No.
Because the first criterion focuses on firstly the use of bones to which some meat remains attached. But it is certainly until recently in these proceedings, it's the how do you define an elephant? Well, everyone.
Well, that's not terribly helpful.
Don't want to get into that.
But Lord, that there really hasn't been a difficulty until this rearguard action since the judgment of the Court of Justice. But my lord, I'm going on to make some more detailed submissions about what intact muscles might mean. But so far,
is it perhaps a sort of circular that it's in the nature of boning that what you take off is intact? But,
well,
because there's no, because it's butchering, I suppose, in a traditional way, by cutting. And even if what you're cutting away is less than a butcher would leave if he were doing it by hand, what you're taking off in that way is not going to be affected by the process of removing it from the carcass, except where the blade touches the meat. And so in that sense, it's intact.
Yes, well, I don't disagree with any of.
I'm just thinking aloud.
So really, I think the point I'm making is if you want more of a definition of boning, the best we can do really is the
Paraphrase in 41.
Yes.
Yeah. I mean, what I was really putting to you, I suppose, is intact in the sense of undamaged.
Well, Lord, if you're putting to me Mr. Mercer's submission that intact muscles means those muscles whose muscle fibre structure has not been lost or modified, save at the cutting point, then I don't accept that, and I'll come on to explain why. But after paragraph 42, my lords, the Court of Justice goes on to make a series of further findings to explain its conclusion that Newby's product should be classified, or a product with the characteristics of Newby should be classified as MSM, and making clear that was the firm view of the court. And in paragraph 29 of our case, if I could ask you to have that open alongside the judgment of the Court of Justice, we've sought to summarise this series of further findings which the court makes. 29.1, we refer to paragraphs 44 to 48, where the court refers to the distinction in the legislation between high pressure and low pressure MSM. There was a lot of focus in the evidence and in the judgment of the referring court on the difference between Newby's product and high pressure MSM, the puree or sludge formed by high pressure MSM. What the Court of Justice is explaining in 44 to 48 is that MSM under the regulation covers both high and low pressure. And in 46, in the first sentence, it says, in terms this type of product, which is a reference to Newby's product, which corresponds to mechanically separated meat obtained at low pressure, like the product in the main at issue in the main proceedings, may by way of exception be used in certain meat preparations and explains the rules in relation to low pressure MSM. In 48 to 50, the Court of Justice emphasised that the drafting of the regulation, by including both high and low pressure MSM within its scope, had sought to build in flexibility 49 and to cater for new methods which may be developed in the future. And in paragraph 50,
I'm sorry, before we get to that, last sentence of paragraph 48 may be important. Yes. It's saying that the distinction made between points 3 and 4 in chapter 3
yes. Yes.
is reflected in the definition in point 1.14, and what I was really drawing attention to is when you say that the presence of the term modification in the definition implies that products obtained through the use of methods of mechanical separation operating at low pressure come in any event, which in the French is en toute hypothèse, within the scope of that definition. So it's really saying, as a matter of definition, if you are within point, if you are a product obtained through the use of methods of mechanical separation operating at low pressure, then you come within the scope of the definition in point 114.
Yes. Yes.
That's what seems to be said.
Yes. And I think the point being that high pressure MSM, or the high pressure methods, result in a total loss of the muscle fibre structure. So the fact that the definition extends to either loss or modification emphasises that lower pressure methods, such as it had said in paragraph 46 was being used to make Newby's product, come within the scope of the definition. And paragraph 49, it refers to recital 20 as supporting essentially a broad interpretation of the definition of MSM, and that's referred to again in paragraph 50, where the court refers to in the second line the possibility that the EU legislature took into consideration from the outset the possibility that new low pressure methods for the production of MSM might be developed, such as the case may be, used by Newby, assuming, and that the words "as the case may be" denote that the Court of Justice wasn't sure whether Newby's method had been known to the EU legislature at the time that the regulation was drafted, but assuming it hadn't, and assuming it demonstrates some innovation, well, it's still within the definition.
May I just ask this? Going back to the last sentence of paragraph 48.
40, I'm sorry.
48.
Yes.
The presence of the term modification in that definition implies that products obtained through the use of methods of mechanical separation operating at low pressure come in any event within the scope of that definition. Well, how far does that extend? Bearing in mind, for example, that in the Newby process, the separation of the breasts takes place by the application of pressure, albeit relatively low pressure.
Well, 2 points. Firstly, chicken breasts and the removal of chicken breasts is no part of Newby's process. That's already been done before they get the carcasses and the bones. That's someone else, not before the court, does that. Secondly, though, I think if your question is, does the final sentence of paragraph 48 mean that any low pressure method of mechanical separation is within gives rise to MSM? The answer must be no.
Well, where does one draw the line between the two? Well, how does one draw the line between the two?
Well, because one applies the other criteria of the three. In this part of the judgment, the Court of Justice is emphasising that in contrast to perhaps the way in which the High Court had approached the matter, that both high and low methods of production were within the scope of the regulation, and that it was wrong to focus simply on the sludge or the slurry, the puree, which is produced by high pressure. It is saying that the EU legislature intended to capture methods of separation such as used by Newby, but Lord, I don't say that avoids having to apply the other two criteria which appear earlier in the judgment. It's simply explaining, I think, and in a number of steps, how it gets to the conclusion that Newby's products are MSM.
Well, in a nutshell for me, would you tell me what the relevant other criteria are in that context?
Well, the other criteria are the ones in paragraph 41. Does it use bones from which the intact muscles have already been detached, or poultry carcasses to which meat remains attached? 2 is answered, use of mechanical separation, and 3, loss or modification of muscle fibre structure by reason of the process.
So it must be 3, is that right?
Well, it could be 1, and it could also be 3.
Poultry carcasses to which meat remains attached. Well, that's going to apply to pretty much any poultry carcass, isn't it, which has not been stripped of meat. So must it not be 3? The answer, would it be right to say the answer must lie in 3? The nature of the modification of the muscle fibre.
Yes, I can see it is likely to reside in 3. I'm not sure that I would accept that 1 is redundant, though, because you do need to have in the case of pork, bones from which the intact muscles have already been detached.
But in the case of poultry, do I understand you to say that the distinction must come in the application of test 3, that is to say, whether there is a relevant loss or modification of the muscle fibre structure?
Yes, and by no, but let me just break that down a little. In the case of poultry, you can either have poultry bones from which the intact muscles have already been detached, or you can have the body of the animal, the poultry carcass. So my point about are these bones from which the intact muscles have already been detached applies not just to pork but also to poultry. But specifically then in relation to poultry, there is the issue of the cutting point qualification, which is there to deal with the particular situation of chicken breasts and may go wider than that in a different case. We don't know, but certainly for poultry, you would have to have regard to the cutting point qualification as well.
Yes, that's supported by paragraph 43.
Yes, and it's the final sentence. I'm going to come back to the cutting point qualification, yeah. but yes, the final sentence of 43 we say makes clear what the purpose of that qualification was.
So mechanical separation by the application of low pressure will only produce this particular character, this particular meat, if the consequence of the process of separation is that there is a relevant change in the muscle fibre structure.
Yes, I mean, assuming you've got the right raw materials which fall within one, then yes, and relevant modification to the muscle fibre structure takes in the cutting point qualification.
Yeah. The point being made in paragraph 48, I think, must be that you have the two categories of MSM in paragraph 3 and paragraph 4 in the annex, and we know that the sludge in paragraph 4 has no fibrous muscle structure at all, yes. And so that's loss of muscle of a muscle structure, and so that's why they say the presence of the term modification must be intended to cover the point 3 MSM.
Yes, I don't rely on the sentence as doing anything particularly much than pointing out the potentially broad scope of the categories. I'm not saying it materially adds to what you have in 41, 42, and 43 in that sense.
Yes. And so you're reading come in any event as really meaning may come.
Mm.
Yes, I think that must be right. Or scope as...
Yes, or fall within the scope, or yes. Okay.
Not falls within the scope rather than satisfies.
Yeah.
So then I think I get to... I think I'd mentioned paragraph 50 in the reference to the applicant's process, Newby's process in 50, and in 52 meat preparations, and you'll recall, think that the questions as put to the Court of Justice by the High Court proceeded essentially on the basis that these products are either MSM or they're meat preparations. And in 52, the court is finding that they are not meat preparations, and there's the reference to products which, like that at issue in the main proceedings, which satisfy the criteria for MSM, cannot be meat preparations. Is the point that's being made. So there's again a clear reference to Newby's products being MSM, and can I just remind the court at this point that one of the oddities about the High Court judgment and the very real difficulties to which it gives rise is the Court of Justice decided these products are MSM and they aren't meat preparations. Mr. Justice Edward Stewart decided they're not MSM and they aren't meat preparations either. And we've explained that difficulty and given the references to that in our case at paragraph 79. Essentially, the judge disagreed with the Court of Justice on MSM. He agreed with them on meat preparations, but the result is that these products don't fall into any category at all in the legislation. That I think the only other candidate is minced meat, but Newby has said consistently that they're not mincing it.
And if we were to find that the judge was right on the first question, what do we say about the second question? I mean, you seem to be saying that they must go on together.
Well, I mean, it does. The very real difficulties to which that conclusion would give rise is, we say, one of the strong pointers that it can't be right to.
Why did you say they weren't meat preparations?
So the Court of Justice says in 52 is the conclusion they aren't meat preparations,
yes.
And in 53 and 54 it explains why they aren't meat preparations, and there are two sets of reasons given there. But what the judge does is to agree with the Court of Justice's reasons as to why they're not meat preparations, but having found initially that they aren't MSM either. So in paragraph 20, going back to 29 of our case, 29.4, we refer to paragraphs 58 and 59 of the Court of Justice, where it goes on to the anti-TSE legislation. And again, there's a reference in paragraph 58 to second line to products such as that at issue in the main proceedings. And it says that, contrary to Newby's view, the application of the classification of MSM to products such as that issue in the main proceedings in order to conclude that their production from raw material obtained from ruminants is prohibited follows from the implementation of the clear intention by the EU legislature in the context of the anti-TSE measures. So the court's view is that its view of the classification of Newby's products is consistent with the intention of the EU legislature, not only under the regulation that it's looking at, but also under the anti-TSE legislation. And then it goes on in 62 to 66 to look at the other area of EU legislation which is relevant, which was the food labelling legislation, and also finds that it is justified to regard Newby's products as MSM, having regard to the food labelling legislation as well. And in paragraph 64 in particular, the Court of Justice says that the practice of calling a product such as Newby's barder meat, 3mm meat, or desinued meat it says towards the end of the paragraph, an illustration of the type of mistake which the EU legislature sought to prevent by adopting the Food Labelling Directive. And 65, not to require that product of inferior quality be subject to specific labelling which informs consumers in clear terms by removing any ambiguity as to its exact nature, would be tantamount to overlooking an essential objective pursued by that directive.
I see in paragraph 55, the court says that really regardless of the MSM issue, Newby's products couldn't in any event be classified as fresh meat because the only category that could conceivably fit would be minced meat, but they fall outside that in the last few words because they are products obtained from bone scrapings.
Yes. So, well, that's some difficulties attached to that finding. We submitted to the lower courts that the Court of Justice had made perhaps a surprising but a legitimate finding that Newby's products were obtained from bone scrapings in the light of information provided by the judge that there could be portions of bone or periosteum in Newby's product. I was refused, the High Court judge disagreed with me on that. He said that the finding of 55 was illegitimate, and I was refused permission to appeal, and he relied on, the judge relied on a letter written by my client a couple of years before, saying that these products weren't obtained from bone scrapings, and I wasn't allowed to argue that the justice had taken a different view, and we should follow it.
Yeah.
So that, and I then couldn't reopen the point before the Court of Appeal, or I was refused permission to do that. So yes. I think I have to disregard and can't take any benefit from 55.
I understand. Thank you.
But I can make the point on meat preparations from 54 in any event. Well, also,
if you're
finally,
leaving,
then,
if you're leaving those paragraphs, is there anything in the paragraph 63 which gives a hint as to what boning is? We have at 41 the paraphrase, the intact muscles have already been detached, and treated as equivalent in 63 is that once that's done, there's only residual meat because it's after the main part has been removed.
Yes, indeed. Well, I think I referred to that phrase a bit earlier on. That's it.
It's all part of the same concept. That they're trying to fix a point where the initial boning ends, and you get into criterion 1.
Yes, indeed. And in a context where boning is not defined in the legislation or in any EU legislation, presumably because everyone thought they knew what it was, but it's just not.
It matters not whether that is 1 cut or 2 cuts. What is the process of initial boning?
Yes.
You have to get beyond that before you get into these criteria.
Yes.
Yes.
Once we get to the residual meat, then we're in the third category, and the only question is whether it modifies the structure.
So far as pork and chicken bones are concerned, yes, if it's residual meat, the intact muscles have been removed, then you're into the third criterion. Yes.
But there, I mean, when we're talking about the cutting in the third category, we're talking about the cutting of the residual meat, or the cutting that went before you got to the residual meat.
Well, it's looking at the residual meat, at the product which is produced from the residual meat. Is there loss or modification of the muscle fibre structure subject to the cutting point?
Yes, but it's a process of cutting off the residual meat which you have to ignore, because that inevitably damages it to some extent. Is that right?
Well, no, Lord, it's not something which you inevitably ignore. It is part of the analysis of whether there has been loss or modification of the muscle fibre structure, but subject to the cutting point qualification.
But does the cutting point, is it your case that the cutting point qualification applies to the residual meat rather than being a reference to the process which is the equivalent of the initial boning in relation to chickens?
I'm sorry, Lord, I didn't really understand the question. Is it?
Well, I mean, 42, it is quite possible to read paragraph 42 as imposing a qualification on the third criterion, that any loss or modification is a loss or modification other than that caused by cutting of the residual meat.
Yes.
But I think your case is not that that's the case, or am I wrong?
I think what is the point of the cutting point qualification is that well, I mean we say the cutting point qualification refers to the cutting of intact muscles like a chicken breast.
That's at stage 1.
Yeah, that's what I'm saying.
I mean, I can understand you maybe say it applies at stage 1, but it could the alternative construction is it applies at stage 3.
And I thought your case was precisely that it's a stage 1 criterion.
Yes.
But your answer to Lord Carnwath's question suggested that you were accepting it as a stage 3 criterion.
Right.
And that's what I was picking you up on.
So I'm sorry, but perhaps I misspoke. I mean, our submission on Newby's process, which is a stage 3 process, is that it's just not the case that all of the pieces of residual meat, that all of the edges of all of the pieces of residual meat are cutting points. That what the Court of Justice meant by cutting point was I think was a stage 1 was the chicken breast, the cutting of the intact muscles, and that if you, as Mr. Mercer tries to do, if you try to extend that so that every edge of every piece of meat that you get out at the next stage is a cutting point as well, then the exception devours the rule. And
I mean, it's a very critical point, because if you're right that the cutting point is confined to stage 1, then you obviously win, because there's modification at the stage of cutting at stage 3, the residual meat inevitably involves some modification.
Yes. Well, it certainly does. It certainly involves some modification in this case. We suspect it probably would in most other cases as well. But there is a question of fact in every case, which was answered to the satisfaction of the Court of Justice in this case. There'll be a question of fact in every case as to whether there is a loss or modification of the muscle fibre structure.
May I ask you this? If I go back to the CJEU test, the first one is, if one ignores poultry carcasses for a moment, the use of bones from which the intact muscles have already been detached. Now, as I understood your submission a moment ago, that meant, or means, the main part of the muscle has been detached, so something more than 50%. Is that right? So you have a process which leaves, let's say, 40% on the bone.
Yeah, not an assumption. I don't put it as a percentage. I answer my Lord Hodge to the effect that the words in paragraph 63, the main part of the meat has been removed, seem to have been intended by the Court of Justice to be equivalent to the words from which the intact muscles have already been detached, which are regarded as equivalent to after boning.
Yeah.
The second and third limbs of the test appear to apply to the methods of mechanical separation of the residual meat, and also whether or not that residual meat suffers a loss or modification of muscle fibre structure. Would that be correct in your submission?
Yes, residual meat subject to the point that limb 1 also extends to whole chicken carcasses.
And as I understand your submission, the qualification that the Court of Justice may be thought to have introduced to the application of this test, in terms of the loss or modification greater than that strictly confined to the cutting point, does not apply to that residual meat. Is that right? It only applies to the removal of the main part of the muscle meat.
Yes, that's the test which enables the Court of Justice to say and to be assured that the chicken breast, even though it's been cut or sheared at the edges, is not MSM. But the pieces of meat that Newby is concerned with, they have edges both at the point at which an intact muscle has been taken away, but they've also got edges where they were attached to the bone. They've also got edges where they've rubbed against other pieces of meat and separated in the machine. There's a whole range of edges, not all of which can be can be cutting points on any view.
And so, have I correctly understood your submission that in relation to that residual meat, any modification of the muscle fibre structure results in it being MSM?
Yes, I mean in the case of Newby's products, where you have pieces of meat with lots of edges from the bone, from the intact muscle, from other pieces of meat, yes, any modification on those edges will give rise to MSM.
Thank you.
I understand, I think that, and it's a very crucial point, but in your submission, what is the logic of distinguishing one cutting point, stage 1 stage, from the cutting points stage 3? You say the cutting point at stage 1 you disregard, the cutting point at stage 3 you don't.
Well, my lord, the logic, and I think Lord Justice Lloyd Jones in paragraph 42, and my Lord Sales, I think, made the same point this morning. There was a logic for introducing the cutting point qualification, which is that the requirement in criterion 1, bones from which the intact muscles have already been detached, the intact muscles have already been detached, that doesn't apply on the wording of criterion 1 to poultry carcasses. Okay. So the MSM definition could read literally apply to the main part of the meat detached from a chicken, the breast, and so forth. And that would create an undesirable and anomalous distinction between chicken on the one hand and other animals on the other, and just not what the legislature could have intended to regard chicken breasts as MSM. So that's the logic.
Yes.
As I understand your case, the rationale is that the court is seeking a bright line rule that mechanical separation after the initial boning or its poultry equivalent meets these 3 criteria if there is any modification or loss of fibre structure, whether cutting or otherwise.
Yes.
That is your case, isn't it?
It is a bright line rule. I think Mr. Justice Edward Stewart referred to it as a zero tolerance approach, but it's subject only to the cutting point.
Yeah. And while clearly we're not concerned with the details of other mechanical techniques beyond Newby's, paragraph 60 is really paragraph 63, which ought to provide reassurance to the producers of chicken breasts and pork chops and other, or what they call the main part of the meat, people who remove the main part of the meat by mechanical means.
Mm.
Yes, my lord, I agree with that, and there are a number of points in the judgment which could give comfort to other producers. Of course, it's in Newby's interests for the purposes of this appeal to raise the spectre of difficulties, but without dismissing the possibility of a difficulty in the future. It's clearly not the intention of the Court of Justice, and nobody has suggested, the Commission, the FSA, no one has suggested that these other producers are in difficulties.
May I just put to you what I understand to be your submission in another way and see if I've correctly understood it? The qualification introduced by the Court of Justice that one's concerned with loss or modification greater than that strictly confined to the cutting point in the case of poultry doesn't apply to other kinds of meat. It wouldn't apply to beef, for example, on your submission. Is that right?
No, my lord, I can't say that it would never apply. I say that it was introduced and is most likely to have been introduced to cater for the position of poultry carcasses, given the missing words in the first criterion. Could it apply to other animals as well? Well, that was what the Court of Appeal considered and you've heard reference to the you've heard criticism of Lord Justice Lloyd Jones referring to prime cuts in his judgment, and he doesn't exclude.
Paragraph 42, I think.
42.
Yeah.
When it goes over the
It was
page.
42. He doesn't exclude the possibility that there can be cutting of that the point to the qualification could apply to other animals. He just doesn't find it necessary to determine. It's the last 5 or 6 lines of paragraph 42. He doesn't find it necessary to determine that question, and we also say it is possible, shouldn't be excluded, but doesn't have to be decided.
But generally speaking, once the main part of the meat, or in the case of beef from the carcass, has been removed, and one's concerned with mechanical separation of what's left, even if it's a lot of meat, your submission is, as I understand it, and correct me if I'm wrong, that any modification of the muscle fibre structure will then result in the meat being MSM.
Yes. And I've explained the different points at which that modification could occur.
Yeah.
But yes, it is a bright line rule subject to the cutting point qualification.
But on the face of it, the cutting point qualification wouldn't apply to that meat, separation of that.
I'm sorry, I didn't mean to go over old ground, but I adopt what Lord Justice Lloyd Jones says in paragraph 42. There may be situations where there remains an intact muscle. I don't want to paraphrase him, but it is possible that there could be other exceptions in other cases, but certainly those would be exceptions.
Thank you.
Well, finally, on the judgment of the Court of Justice, 67 and the dispositif are worded in the same way, and that they express the conclusion of the Court of Justice on the case. In fact, so if we look at the dispositif, the Court says that the relevant provisions of the regulation must be interpreted as meaning that the product obtained by the mechanical removal of meat from flesh-bearing bones after boning or from poultry carcasses must be classified as mechanically separated meat within point 1.14, since the process used results in a loss or modification of the muscle fibre structure greater than that strictly confined to the cutting point. And you'll note the contrast with paragraph 42, where the words insofar as were used instead of since, and there is a difference in the wording in the various language versions. This isn't one of Mr. Newby's mistakes of translation. Sorry, Mr. Mercer's mistakes of translation. The reason for the difference of wording, we say, and the reason why the conclusion is expressed as a since, as a firm conclusion in paragraph 68, is that 42 that states the general principle insofar as, then the court goes through the various specific factors relating to Newby's product, and I've gone through all of the different reasons that it gave, and having gone through all of those reasons, it then reaches a firm conclusion in the case of the product which is at issue on the preliminary reference. So again, we say there's no doubt as to what the court meant, and no doubt that it considered that Newby's product involved changes to the muscle fibre structure other than strictly at the cutting point. One simply can't read the dispositif in any other way.
Yes, that's to say the cutting point created by boning.
Yeah.
Yes. Yes, the cutting of intact muscles is how we put it.
And so on that approach, the court's conclusion doesn't depend on any facts which are in controversy.
Any facts which are...
Which are in controversy.
No, indeed.
I find that quite hard to reconcile with the way the conclusion at the end on page 1435, the dispositive paragraph. It looks there as if the cutting point is applied to the third stage, because you've already moved beyond the point of getting up flesh-bearing bone or a deboned or a carcass. And then you're asking, like, what is the cutting point in relation to the third stage, aren't you?
Yes, the cutting point is a qualification on that is introduced and applies in relation to the third criterion.
But if they simply were using, I mean, you seem to be saying the cutting point could have been simply meaning a reference back to the mechanical removal of flesh from flesh.
Returning to the matter we discussed a while ago, I mean, what is your position? Does the cutting point apply to criterion 3 or only to criterion 1?
But I think he said it applies only to 1, but I just wondered how you reconcile that with that final point.
Would it not, well, perhaps it might come in at stage 3 in that the, ex hypothesi after boning, you're left with residual meat whose structure will have been modified at the point where where other meat has already been removed by the boning process. And so you have residual meat, its structure has been modified along its surface, and the issue is whether the process used in recovering that residual meat causes further damage to the structure of the meat.
Well, look, I put it this way: so far as poultry carcasses are concerned, which, as I mentioned, we understand to be the reason why the cutting point qualification was introduced at all, that it must be a qualification which applies at stage 3, because they pass stage 1. I think one does have to distinguish between the bones on the one hand and the poultry carcasses on the other. The poultry carcass passes through stage 1, even if it's entirely whole, still has its breasts intact, and as is made clear, I think, in paragraph 43, the course is discussing the third criterion, and it introduces or discusses the cutting point in relation to the third criterion, and in the specific context of chicken breasts being detached from the carcass of the animal. So I can only, I didn't make myself clear before, but I can only submit based on that and based on our understanding of the logic for the cutting point qualification, that it is, in the case of poultry carcasses, something which is considered at stage 3. But at whatever stage it is considered, it is crystal clear that Newby's product has severed edges, not just at the point at which the chicken breast or whatever it was is removed, but also at the point at which it comes away from the bone, and also at the point at which it's sheared away from other pieces of meat. So whatever way one cuts it, as it were, Newby's product has modifications which go beyond the cutting point.
And it really doesn't need a microscopic examination to tell you that, because there will be damage of some kind, which extends beyond the cutting points imposed when the breasts were removed.
Yes, it doesn't need a microscopic examination, and that is a choice, or it ought not to. That is a choice which the Court of Justice had. It was presented with arguments. This ought to be something which you have to get Professor Groves in to test for you, so you can tell whether your product's MSM or not, or the Commission's line, which was, no, it's a bright line rule, and they went for the bright line rule.
Yeah.
I rather got the impression that the choice made by the CJEU was precisely to get away from issues of microscopic examination, because that's involved in the brightness of the line they're trying to create, and their rejection of the idea that you examine whether the breakdown in muscle fibre is significant or not, and they say that's not the test.
Yes.
But you wouldn't go so far as to submit that microscopic examination isn't the sort of thing which is regularly done in the context of food regulation?
No, it is. It is regularly done.
Yeah.
And sometimes it's significant to the classification of the product, and sometimes it's not. And the Court of Justice, the effect of the judgment of the Court of Justice is it's generally not here.
Yeah.
So, well, as having taken you through the various reasons given by the Court of Justice, this was, we say, a comprehensive ruling against Newby and against the UK, not just on a narrow point of interpretation of 1.14, but on a whole range of other issues which the Court of Justice viewed as supporting its interpretation. To use the words of Lord Carnworth in the Amia case, which I'm going to come to in more detail in a moment, paragraph 145, it is impossible to read the judgment of the Court of Justice as leaving open the possibility that Newby's product is not MSM.
But on your approach, we don't get into Amia at all, because there's no question of having been under any material misunderstanding.
No, we are a very long way away from Amia in our submission. Perhaps I'll go to it briefly now. It's in the core volume at tab 4. And can I start with paragraph 55? I mean, the facts and what led this court to depart from the ruling of the Court of Justice are somewhat complex. But the essential reasoning for why this court did depart by a majority from the view of the Court of Justice is set out, first of all, in paragraph 55 in my Lord Reed's judgment. And the difficulty was, see the third sentence, it's particularly unfortunate in those circumstances that, as I've explained, the reference to the Court of Justice failed to fully reflect either the facts on the basis of which the court must proceed or the issues at the heart of the dispute, with the consequence that the Court of Justice did not fully address those facts or those issues. And the explanation which my Lord had given is in particular in paragraph 48, where you explained in paragraph 48 that the terms of the reference, second line, the terms of the reference resulted in the Court of Justice approaching the facts on a different basis from that which the referring court was bound to adopt. It left out of account a number of matters found by the tribunal relied upon by LMUK before the national courts. And those various matters are then set out. And 49, the court's not to be criticised for failing to take those matters into account. They were not focused on reference, and the court understandably confined its assessment to the matters raised in the questions referred. And so far as Lord Hope was concerned, also in the majority, at paragraph 103 on page MS131. The problem identified by Lord Hope in the second half of paragraph 103 he says, "But I do not read the ruling contained in this judgment as determining how the principles that it sets out are to be applied to the facts of this case. That's our responsibility. The problem we face in looking to the judgment for guidance is that it does not say that the payments made by promoters to redeemers," and so forth. He explains what the Court of Justice doesn't give guidance on, which he regards, third line from the bottom of that paragraph, as the competing arguments which were advanced before him and what is really at issue in the case.
And the problem there was the Court of Justice had given legal guidance, and if you applied the legal guidance to the facts as set out in the reference, then they led to the result the CJEU reached. But if you applied the guidance to the facts as the domestic courts knew them to be as a whole, a different conclusion followed.
Yes, yes, and I mean, the difficulty was with the reference, yeah. and it was a reference which was made without a reasoned judgment, or terms agreed by the parties, but no comprehensive account of the proceedings, the issues, the facts. What we had in this case, in Newby, was a lengthy reasoned judgment by Mr. Justice Edward Stewart that you have seen, which referred to, and with admirable clarity, the issues, the evidence, his findings, and then stated his provisional conclusions. And he also included, and it went with the order for reference, the majority of the original evidence which had been before him. Now, unlike in Amia, it then followed that the judgment of the Court of Justice was based on the evidence and on the arguments which were critical to the domestic proceedings. And what has happened since the judgment of the Court of Justice in our proceedings is that there has been effectively a challenge to its decision and a criticism of its decision based on evidence and arguments which simply weren't in the proceedings before the reference and weren't before the Court of Justice. And really were only formulated, and I paid tribute to my learned friend's ingenuity already, but they were only formulated, all this new evidence, new arguments, by way of a rearguard action to persuade the domestic courts that the Court of Justice can't have meant what it manifestly said.
And you would say the whole exercise has been based on a misunderstanding of the qualification about the cutting point.
Yes, yes, and for the reasons given by the Court of Appeal, which I can't significantly improve upon. But can I make 2 points or address 2 points that my learned friend made, which I think go towards or are part of his case as to why the Court of Justice didn't have the right evidence before it. He said that the evidence that the Court of Justice had was focused on the stage 2 product, the end product, as it were, whereas he says we now know since the ruling of the court that we should have been looking at stage 1. And the new evidence that went in after the Court of Justice ruling was concerned with the stage 1 product. Well, as we don't accept that submission, we don't accept that the Court of Justice was looking at the wrong stage. These proceedings were a challenge to a moratorium on the production of desinewed meat. Newby brought its challenge to argue that its desinued meat did not fulfil the criteria for MSM. What it was material to test and to argue about was the product which Newby produced at the end of its process, which it calls desinued meat. Now, as it happens, Newby's product is produced in 2 stages in 2 different machines. But as is apparent from a guidance note that Mr. Justice Edward Stewart refers to in his referring judgment, DSM is made by other companies in 1 stage, in 1 machine. So it's the end product which the parties understandably focused on and which was rightly put before the Court of Justice. And we would also say that stage 2, the process whereby what initially comes off the bone is fed through the plate so as to remove gristle and sinew and so forth, we would regard that as part of the process of separating the meat from the bone. It's temporally it takes place in a different machine immediately after the meat has come off the bone, but it's by way of filtering or purification of what comes off the bone and is part of the same process. So the parties, Mr. Justice Edward Stewart and the Court of Justice, did not proceed on a false basis when they looked at the evidence, the extensive evidence in relation to DSM. The second point that I wanted to make about mistakes or misapprehensions that the Court of Justice might have been under is the point raised by my lords this morning. Well, was the Court of Justice told that chicken breasts are customarily taken off the carcass not by a knife, but by some form of pressure? And the answer, and I've looked at the observations and we've had a look through the evidence, the answer is no. We don't think that the court was told that. And my lords may be right in thinking that is perhaps a misapprehension on the part of the Court of Justice. But we say it's simply not material either to the reasoning of the Court of Justice or to the outcome of this case. The reasoning, and it calls it the cutting point, the point at which the chicken breast is removed from the bone. But the concept and what it's getting at by the cutting point can't differ and wouldn't have differed according to whether the instrument used to separate the breast was sharp or blunt. It's the same point. And secondly, it simply doesn't matter to the outcome of this case because the cutting point qualification does not matter to the outcome of this case. Newby's product does not benefit from that qualification, as is manifestly clear from the judgment of the Court of Justice. So this is simply not an AMIA case. There's no error of understanding of the facts by the Court of Justice. It's not even a de Groot case, which is the other authority that my learned friend relied upon. In that case, the Court of Justice decided a point which had not been referred to it. It decided that the French law was contrary to free movement of goods, when that was not the subject of the question which had been referred by the National Court. That question had referred to the detailed legislation relating to vegetable seeds. So having decided a question which hadn't been referred, and I think Mr. Mercer showed you the passage where the Court of Justice referred to its conclusion being based on common ground. It thought that it had enough to decide the point, even though the point hadn't been referred. It then went back to the French court and they looked at the point further and found that the Court of Justice's ruling was correct. But that's simply not this case, the Court of Justice was asked questions directed to the right end, to the classification of Newby's products, and it answered those questions and no others. So it's simply not within that line of authority, or indeed any of the other authorities which my learned friend has included in the bundle. Now, can I? I'm sorry, I'm going retracing my ground a little. I need to say something more about the cutting point qualification and why, in our submission, that doesn't apply to Newby's products. Giving appropriate respect to the Court of Justice, we say that the fact that it held very clearly, as I've shown you, that Newby's products, or a product with the characteristics of Newby's product, is MSM, is the strongest possible indication that the cutting point qualification was not one from which Newby's product can benefit. And it is a factor to be given very substantial weight, we say, when considering Newby's submissions as to the correct interpretation of the cutting point qualification. The interpretation which this court arrives at should, if due respect is paid to the ruling of the Court of Justice, we say be resolved consistently with the outcome which the Court of Justice reached in this case. Now, can I ask you to turn, please, to paragraph 34 of our written case. And the way in which we address Newby's submissions on the cutting point is to focus firstly on the three criteria, the three MSM criteria in paragraph 41 of the Court of Justice's judgment, and to say that Newby's products satisfy those three criteria before one gets to consideration of the cutting point. Now, there's only any serious argument about the first of those criteria. The second one is accepted. Newby does use methods of mechanical separation, and the third is also accepted and was found by the judge. There is some loss or modification of the muscle fibre structure. But what Newby has sought to argue in the past and still maintains is that its product does not fall within the first criterion because it's not produced.
With respect, I'm sorry to interrupt my friend. We don't maintain that. We lost on that, and we're not maintaining it.
Well, I'm grateful for that indication. So it is accepted that Newby's products are produced using bones from which the intact muscles have already been detached. In which case you may be wondering, as I am, why Mr. Mercer persisted in his submissions with arguments that the intact muscle meant the muscle whose muscle fibre structure was intact.
Well, we're not just looking at Newby's product, we're looking at it more widely.
Well, certainly if I don't need to argue this point, I won't argue it, but I
have got a concession on one, that no one disputes criterion 2, so you say it's all about criterion 3.
So it's all about criterion 3, and in fact it's all about the cutting point qualification, because read without the cutting point qualification, criterion 3 is satisfied and was held to be satisfied by Mr. Justice Edward Stewart. So when one gets then to the cutting point qualification, that's paragraph 41 onwards of our case. And in particular, if I could start with paragraph 48. Newby accepts that each edge of its meat fragments, or that at each edge of its meat fragments, the muscle fibre structure will have been modified as a result of it being separated from the bone or from another fragment of meat. So to bring itself within the cutting point qualification, it would have to show that every one of the edges of its fragments of meat, whether the edge which was against the bone, whether it was against the another fragment, or whether it was against the breast or some other intact muscle, that all of those edges are cutting points. And if it can't persuade you of that, then axiomatically there will have been a modification of the muscle fibre structure other than at the cutting point. And we've set out in paragraph, we set out in our case why the Court of Justice simply could not have meant that, could not have meant what Mr. Mercer says that it meant. And can I take it in this order? Paragraph 53 of our case, if it had meant that, it would have, to use the judge's phrase, thrown the baby out with the bathwater, introduced an exception which consumed the rule, and it should not be regarded as having done so. Paragraph 54 of our case, if Mr. Mercer is right that the Court of Justice had intended to hold that each and every boundary, each and every edge of the meat fragments which make up Newby's product is a cutting point. So the question is simply, as we put in paragraph 54, whether any product's muscle fibre structure, any piece of meat's muscle fibre structure has undergone a loss or modification anywhere apart from the exterior boundary. The Court of Justice would surely have said so. And it would have sought to address the factual question, which Mr. Justice Edward Stewart held still fell to be addressed by him, as to whether the modification of the muscle fibre structure was confined to the edges or not. But plainly, the Court of Justice didn't think that there was any further factual question to be investigated. Why? Because it considered that Newby's product was MSM for the reasons that it gave. So as we put it at the end of paragraph 54, the submission that Newby still maintains is impossible to reconcile with the language used by the Court of Justice and with its conclusion reached without the need for any further factual inquiry. The correct explanation for the cutting point qualification, we say, is that given by the Court of Appeal at paragraphs 39 to 40, that it's not an exception of general application. And he gives the reasons why not, which we commend to the court. We've set out in paragraph 52 of our case where we believe the language of the cutting point came from, which was directly from Newby's arguments about the removal of chicken breasts, which it referred to at that point as cutting, although later filed evidence to a different effect. And we add only, and it's a point that I've made already, the explanation that Lord Justice Lloyd-Jones gives in paragraph 42 as to why the cutting point qualification was introduced at all. And one sees about just below halfway down the paragraph, as Mr. Coppell points out, it must follow, and it follows from the Newby's product satisfying the first criterion, that the product of Newby's process is not obtained by cutting intact muscles. Intact muscles have already been detached from the bones. In the case of chicken carcasses, the requirement that intact muscles have already been detached does not apply. It seems to me that this explains why the Court of Justice had to address the question of the cutting point in the context of the three limbs. Now, Newby submits that there are three, or submitted that there were three problems in particular created by the analysis of the Court of Appeal of the cutting point qualification. I just need to address you briefly on those. The first problem, it said, or Mr. Mercer said this morning, is that the Court of Appeal's approach is to the effect that intact muscles only are regarded as meat, and therefore that the Court of Appeal's approach has the effect of excluding from the category of meat a lot of produce which people would normally describe as meat. To which the answer is, and my Lord Sales pointed this out, that it can still be meat, but it may be mechanically separated meat, depending on whether it falls within the definition or not. So that's a non-starter. The second problem which my learned friend identified is that he said that the Court of Appeal, and by extension the Court of Justice, had adopted the wrong approach to intact muscles. And he says the right approach is that an intact muscle is a muscle whose muscle fibre structure has been modified or destroyed beyond the cutting point. And this then leads him, I think, still to make the submission that Newby's product is obtained by cutting intact muscles, and therefore that they can benefit from the cutting point qualification. We submit the obvious answer to that submission, and the submission that intact muscle means intact muscle fibre structure, essentially, is that it creates an inconsistency between the third criterion for MSM and the first criterion. Because he accepts at the first stage, at the stage of the first criterion, that the intact muscles have already been removed from the bones which Newby uses. But then it must follow, at the stage of the third criterion, that there are no longer intact muscles from which Newby can make its product. So his approach creates an inconsistency. And we have set out in paragraph 59 of our case both our positive cases to the correct meaning of intact muscle, paragraph 59, and then in paragraph 60, a number of responses to the argument that I'm dealing with from Mr. Mercer, that intact muscle is not simply muscle. It's not simply muscle whose muscle fibre structure has not been lost or destroyed. But I simply refer the court to paragraph 60 of our case, And I draw particular attention to paragraph 60.4, where Newby recognises what it describes as a complexity in its argument, which means that it's contrary to the words used in the judgment, which is explained as effectively a translation error. And it asks you to read the intact muscles as some of the intact muscles, so that Newby can still say that there are some left at the third stage. But we've explained why that doesn't work. I think the only other well, I should say, finally, on that point, Mr. Mercer, in his paragraph 45, makes a number of submissions in support of his construction of intact muscles. I think the only point I wanted to add in response to his paragraph 45 are that 45.2, reliance on the European Commission's letter a couple of years after the ruling of the Court of Justice can't get him home. And 45.3, the court should be aware, and you may have seen some of this in Mr. Mercer's submissions this morning. Newby's submissions all the way through these proceedings have been based on what it describes as undisputed facts of butchery, some put forward by Mr. Mercer himself, some supported by evidence, some not. There was a lot of this when the case came back from the Court of Justice in front of Mr. Justice Edwards Stewart, and what he actually found in paragraph 77 of his judgment at MS 1393 was that what Mr. Mercer said was obvious and undisputed in relation to wishbones couldn't actually be made out on the evidence, and he didn't have sufficient evidence to decide it. And I just make that same point where you're asked to accept facts as undisputed facts of butchery and to proceed from that starting point. The judge wasn't satisfied with the state of the evidence, and we say that you shouldn't be either. The third and final criticism which Mr. Mercer makes of the Court of Appeal's approach is that it renders the third criterion superfluous. And he says one must give the third criterion for MSM content, and our approach and the Court of Appeal's approach doesn't do that. Now, our responses to that are as follows. Firstly, it's not surprising, this court should not be surprised, that there may be an overlap between the three criteria set out by the Court of Justice in its paragraph 41. The court made clear in the first sentence of paragraph 41 that the three criteria were cumulative and they must be read in conjunction with one another. So some overlap, we would say, is unsurprising. It is not correct that the third criterion is, on our approach, superfluous. The conclusion of the Court of Justice in this case was based on the evidence in this case that Newby's process caused loss or modification of the muscle fibre structure. A different process of mechanical separation is likely to have the same effect in similar circumstances, but that will be a matter for evidence in a future case. In relation to poultry carcasses, the third criterion, as I think I've already tried to explain, the third criterion operates as a necessary and important limitation. They get through stage 1 of the test, even though all of the meat may still remain attached. So it is necessary to deal with them at stage 3. Stage 3 is likely to be of lesser significance in relation to pork products, but not of no significance. Of lesser significance because the cutting point qualification is much less likely to apply to a process which uses flesh-bearing bones after boning. But, as I've already submitted, the Court of Appeal did recognise that there may be cases in which an intact muscle remains on the bone after initial boning, to which the third criterion may be significant. So, whilst in accordance with the bright line approach of the Court of Justice, the great majority of cases in which meat is removed mechanically from flesh-bearing bones after boning will produce MSM, because the boning will have cut away the intact muscles, it is not the case that that is inevitable. And it's not possible to prejudge the outcome of future cases about different processes which may be supported by different evidence. Well, Lords, I think the only point that that remains for me to cover, which I probably should have done already, but I don't want to forget, in the my learned friend's submissions about the proper interpretation of the Court of Justice's judgment, much is made of the proper role, what is the proper role of the court, being interpretation and so forth. We say that there is nothing untoward or unusual or improper about the Court of Justice expressing a clear view, as it did in this case, on the correct classification of a product which is the subject of a reference. That is something which it does very frequently. We've given you 4 very recent examples from the last couple of years in the bundle. Can I just give you the references without turning them up? The 4 cases are medical imaging, Volume 4, Tab 47, MS 1047. And what you're looking for is in paragraph 34, where the court expresses a clear view as to the correct classification of a product such as that at issue in the main proceedings. So the court is not presuming to formally decide the domestic proceedings. That's a matter for the domestic court, and of course the domestic court, as in AMIA, will be alert to check that the court's ruling was based on the appropriate facts and so forth. But there is nothing wrong with the court expressing a view as to the right outcome for a product such as that at issue in the main proceedings.
What was the MS reference to that?
So that's MS 1047, I think is the beginning of the first page, and paragraph 34. Sorry.
1053.
.1053.
1053, thank you. And well, there are 3 other cases in the bundle to exactly the same effect. Cry and Hop, Tab 4, Volume 4, Tab 48, MS 1055. Pilato, Volume 4, Tab 49, MS 1063. Saxa, Volume 4, Tab 50, MS 1073. And we've also given you a couple of pages from Brober and Fenger, which you'll have seen the High Court referred to, and indeed the Court of Appeal volume 4, tab 53.
Page.
And that is at MS 1110. It's only a couple of pages. We've also given you an example of a classification case where the Court of Justice doesn't have all of the facts which it needs to express a view on the treatment of a product such as that in the main proceedings, and that's Medtronic, volume 4, tab 52, MS 1082, where it's more in the way of guidance, and it's for the domestic court to decide the necessary facts. None of that, we say, is inconsistent with my Lord Carnworth in the Amina case. That's volume 2, tab 23, MS 624. Where my Lord Carnworth quotes the Court of Justice saying that formally the task of classification is one for the national court, because the Court of Justice doesn't necessarily have all of the information available to it, and the national court's in a better position. Well, that's not inconsistent with the authorities that I've listed out for you. The Court of Appeal is still in those authorities formally giving guidance, but it is expressing a very clear view at a level of abstraction. It's not this product in these proceedings should be classified as follows. It is at a slightly higher level of abstraction, which leaves little room for the domestic court, but it's still consistent, we say, with the authority quoted in Amina. So, my Lords, I'm sorry that was a little out of order. I think, unless I can assist further, those are my submissions.
Thank you very much, Mr. Cotton. Mr. Lee, do you follow? Mr. Mercer.
Thank you, Lords. Learned friend spoke at the beginning of his submissions about comity respect, about the fact that the exception, if interpreted in the way that Newby contends, would destroy the rule and undermine the CJU's intent that Newby's product is MSM. But of course, no, the exception deals with the fact that cutting or separation inevitably damages muscle fibre structure. In terms of undermining the intent, that depends on the assessment of the facts, whether facts are material and complete. Those are issues for the National Court. The learned friend said that this court should focus on deciding the case before them and not give general guidance. In his own written case of 55.3, he observes correctly that the CJU interpretation applies to all products. So on the law, this is obviously totally general. On the facts, of course, the specific facts of this case are before the court. The learned friend then went on to there was discussion of paragraph 48 of the CJU judgment, and the last sentence of 48. That's at, in the CJU judgment at MS 1432.
Yes.
And my Lord, we simply adopt what my Lord Reid said there, that obviously if one's just dealing with high pressure MSM, one only needs to have the word loss.
Yes.
Because one's dealing with low pressure MSM as well, it's a question of modification. But we do agree with the FSA that you must still apply the other criteria,
yes,
the first and third criteria.
Yeah.
And the words in any event may reflect an assumption that there is a change to muscle fibre structure. We would say an assumption which is not justified on the facts. On the meat preparations point, and on my learned friend was making a point about how do you classify our product? Well, of course, here we're dealing with the product of stage 1. And the judge's finding at 92 is that our product is fresh meat. How it is classified thereafter, he also finds at 94, no reason why, on the evidence, it couldn't be classified as minced meat. That's not his task to classify it. The task of classification for labelling purposes is trading standards. Trading standards have to do that. My learned friend refers to problems and difficulties. There's no evidence in problems or difficulties.
So as far as you're concerned, if it's not a meat preparation, it doesn't matter.
Doesn't matter. No, because it is fresh meat. We're dealing, because we've moved, meat preparation is the product of stage 2. We moved to stage 1 because, and I don't criticise this, the Court of Justice is absolutely right. You're looking at the effects of removal. And really, we ought to have been focused on stage 1 and originally. We weren't, because of the way the FSA looked at it. They wanted to analyse stage 2. So that was the test we were addressing. That was the guidance we were addressing. The learned friend relied on the Court of Justice reference in 63 to residual meat. But one needs to, I don't think he mentioned paragraph 62 of the judge's judgment at 1390. It doesn't really assist. It depends what you mean by residual meat. The rather pejorative tone implies, of the CJU, implies that the proportion of meat left on the bone is fairly small. That doesn't reflect the evidence, which is the effect that the bones often consist of 50% meat. So that's, I mean, obviously residual as a sort of term of, without not using it as a term of art, what's left after there's been boning is fine, but not with the pejorative overtones. And then learned friend then seemed to say ebb and flow on whether the cutting point was directed at the first criterion of 1.14 or the third criterion. But where does it arise? It arises in paragraph 42 of the CJU judgment. And 42 is definitely dealing with criterion 3. My learned friend made points about criticised our case as saying, well, there are a variety of edges where there are cuts or separation. And we say, by reference to our diagram, well, of course, all meat has that issue. Because when the portion is separated from the rest of the carcass, because it would generally be, it's in the regulations, as I gave your lordship this morning the reference, there will be often a quartering of the carcass, and then the division into smaller portions. In that process, there will be cuts from the other part of the animal. There will be removal of skin. There will be the cut where the boning process is carried out. But what is the learned friend didn't really have any answer, well, he didn't have any answer to the rationale for the different treatment of the meat on either side of the line. And by meat in that context, of course, I'm talking about the labelling definition of meat, skeletal muscle, as opposed to MSM, which, although a form of meat, does not count for the meat content when you are making, say, sausages or products. MSM does not count for meat content. That's what this case is about, and I should have said that this morning. So the problem is that the lack of the rationale for a difference in looking at the initial cut. So on my diagram to the right, for your lordships, that is definitely meat in the labelling sense, but this meat in the middle. If there's a hand cut, my learned friend didn't take up my gauntlet, which I threw down, if that's hand cut, then that is also meat in a labelling sense. It's only if it's a machine cut. And really we get back to there, my Lord Reed's statement, well, residual meat is where the other meat is removed. The structure is modified at the surface of the point of removal. That's the cut 3, obviously. And then the further question is whether the process gives rise to further damage. And that depends entirely on the process used to achieve whatever other points of separation there are. And the process may or may not achieve the denomination, the labelling denomination meat. But it may, as we contend the judge's findings justify in this case. I mentioned in passing 62 and 63 of the Court of Justice. That's 62 and 63 are dealing with the labelling definition. I should perhaps just turn it up because 63 it was dealing with the what may be labelled as meat for 2001. So it's core tab 2, page 94, MS 94. And what the labelling definition is saying, it's in the end of the first paragraph, it's excluding from the labelling definition what was originally called mechanically recovered meat. It's common ground that applies to MSM. And so MSM is just outside the labelling definition of meat. So it's in MS 94. The reference is in 62-63 to things like fat and connective tissue, are simply looking at, there are parameters which meat has to satisfy in order to be, or which a product has to satisfy in order to be labelled as meat, those fat and connective tissue, but they are nothing to do with whether something is MSM or not. So when one reads 62 and 63, one needs to have open page 94 in front of one and think that, well, what they are saying is, of course, there is a labelling problem if, as we believe, the product in this case is MSM. But that begs the question as to whether this product is properly labelled MSM. And the references to the chemical analysis in the bundle are MS1 for page 94, MS 1648 and MS 1651 to see the chemical analysis of this meat by reference to the fat, connective tissue and bone matters. So, and then my Lord Sales suggested that the Court of Justice was trying to get away from microscopy. Of course, the problem for the Court of Justice is that the criterion 3, in principle, asks for analysis. What our submission is that what remains from the Court of Justice is a reasonably bright line test, because you only ignore the damage at the cutting point. Now, if you are using a sharp knife, of course, we discussed pressure earlier. A knife is nothing more than pressure focused at a very small, very tiny point. But if you are dealing with a cut which has occurred by a sharp knife, maybe you would not need to analyse the edges of the product, because you would know that there would be any damage to the muscle fibre structure would be limited to the cutting point. But it is still open to any operator on the Court of Justice's test to show that his products are an equivalent position to meat which has been cut. And they are not to be shut out from using microscopy for that purpose. We say as a matter of the true interpretation of the Court of Justice judgment. Learned friend said that if the Court of Justice had in fact meant, well, it's any edge, then the Court of Justice would have analysed the facts. But so far as the Court of Justice was concerned, one sees from paragraph 34 of the Court of Justice decision that they believed that there was a general loss or modification of muscle fibre structure. So there was no need to say, in this case, you need to carry out further measures of inquiry when it gets back to the National Court. Because their belief was that there was something general about the damage to muscle fibre structure in this case. Learned friend made the submission that following the application of criterion 1, all intact muscles have been removed. But, I mean, first of all, the court was not purporting here to legislate, to modify the deboning test in the first criterion of 1.14, and still less could they, as the court correctly pointed out in 171-2 of HS2, and the Court of Justice itself in the Metrans case. And the practical perspective is here essential for those sitting behind me and for those who have to read the judgment, because from a practical perspective, we know the evidence is clear that there are large amounts of skeletal muscle remaining on the bone after the deboning process. The intact muscles, we do say in our written case, the intact muscles, as we know, the Court of Justice deliberates in French. And so one sees in the French text, les muscles entiers. And I should just say that entier, the Larousse definition includes intact. But when the French say les muscles entiers, it's a matter of appreciation for the translator as to whether they are referring to intact muscles or the intact muscles. Because when you say just intact muscles, if you said in English intact muscles, in French you would render that as les muscles entiers, without meaning all. And all just doesn't make sense. And all, also, it simply removes the practical effect to paragraph 43 of the Court of Justice judgment, which assumes, in 43, that intact muscles remain, as we know to be the case. The product obtained by cutting intact muscles. Well, work is to be done, says paragraph 43, by the third criterion. My learned friend then said, towards the end of his submissions, that the CJU's finding was correct in this case because Newby's process caused loss or modification to muscle fibre structure on the evidence. Well, I mean, we agree with that submission. That is used for the judge, we say. It's not consistent with his other submission, which is that the cutting point doesn't apply to residual meat, however that is to be termed. And of course, residual meat. We're dealing here with the need for definitions which are, meat is carefully analysed in the definitions, both in the labelling and in the hygiene context. And we say he's right when he said that the CJU's finding was correct. Well, he's right in his approach to the law. He's wrong on the facts. But when my learned friend said the CJU's finding was correct because Newby's process caused loss or modification of muscle fibre structure, we say, well, that depends on the facts. And that's because the work is to be done by the third criterion. And on the classification cases, the problem from learned friend is Lohman, and his attempt to distinguish Amina doesn't succeed because what the Court of Justice might say, as one sees in what the Court of Justice might say in terms of trying to help the National Court doesn't help us as to what is the binding part of the decision. My Lord Carnworth asked me before the break about an application, and perhaps I misunderstood the question, but for an application of Article 11 TFEU in a specific case, it's the case in our written case, Preußen Electra, which was Preußen Electra, it's in the core bundle of authorities, and it's particularly paragraphs, we referred in our written case to paragraphs 71 to 81 and 231 of Francis Jacobs.
Sorry, where is it in your case?
It's written in our written case, I think it's 43, my lord. Sorry. No?
Yes, 43, Preußen Electra.
Yes. Sorry, I was in my learned friend's written case. Yes, 43. So that's direct application. And my Lord Sales referred to the qualification placing chicken carcasses in the same position as flesh-bearing bones after boning. But of course, 1.9 of the paragraph 1.9 in Annex 1 defines chicken carcass as the whole carcass. And the cutting point qualification, we say, is simply designed to leave out of account modification to the muscle fibre structure at any cutting point, and it's not expressed in paragraph 42 or 43 to be, or the dispositif, to be limited to chicken breasts. So, Lords, unless there are any other matters which I can assist your Lordships with.
Perhaps I could ask just one matter. I'd like to be clear if what, if any, videos we're permitted to look at.
Well, Lord,
I know there are a number that have been submitted by the interveners, but I'm wondering if there are any that have been submitted by either of the principal parties.
I mean, look, my Lord, it's not my application to admit the additional evidence.
No.
I'm not aware that there are other videos
Right.
in the evidence.
That's what I was wondering.
And all we'd say is that, I mean, the other evidence, the FSA is not saying there's anything wrong with the evidence.
Yeah.
And in a sense, the video in particular, Mr. Griffith referred to in Mr. Griffith's statement, was instructive to me, but who knows whether it's instructive to your Lordships.
I confess I've looked at it and I find it quite interesting, but I don't know whether Mr. Coppell minds that or not.
Well, Well, I don't mind. We do say there's something wrong with the evidence, though, both as to timing and as to content.
Can you help me on one point of fact which I'm not quite clear about? A chicken carcass still has the breast on it, does it? Where do we find the evidence of that? I mean, one sees that fairly graphically in the video. I'd like to, where is it in the evidence?
It's in 1.19, my lord. It's in tab 1 of the core authorities.
That's the passage you just referred to. It's a
Yes.
definition in Annex 1.
Yes.
Carcass
Carcass
includes the whole thing.
Sorry, can you give me a page number?
Yes, page MS 26.
It's not so much a matter of evidence as definition.
Indeed.
Legal
Yes.
definition.
Indeed.
Well, sorry, could you point me to what you say is relevant?
It's 1.9 on page 26. Carcass means the body of an animal after slaughter and dressing. So when it refers to poultry carcasses in 1.14, or from poultry carcasses, that is referring to the dressed poultry carcass.
Whole thing.
Whole thing. Well, I suppose it may, yes, in principle it can be the whole thing.
Sorry, I'm being silly about this, but dressing in this context means what?
It's like washing and taking the guts out.
I see, that's all. So
that comes
everything
from
else
behind.
is a carcass.
But not skinning.
I mean, the skinning seems to be part of the initial part of the process prior to removing the breasts.
But there's no doubt that the breast, removal of the breast is stage 3.
Yes.
No.
No.
Stage 1.
Yeah.
Removal of breast.
No, with respect, my lord.
Oh, no, I see what you mean, yes.
Because it can't be within criterion 1 because it's poultry.
It can't be because of
And
the
so,
definition.
so for poultry, all poultry, you don't apply criterion 1, you go straight to criterion 2 and 3. So second one, is it mechanical? And thirdly, well, does it result in loss of modification of muscle fibre structure? Yeah. And of course, it's not just about...
Now, it's quite important this, that we should be clear, because, I mean, the video I saw showed me a chicken carcass with the breasts going through a machine, and the breasts are pulled off, which is a process. Yes. And I understand that's stage 3. Is that right?
Yes.
Yeah, thank you.
And for the avoidance of doubt, the chicken carcasses that Newby deal with have already had the breasts removed.
My lord, no, I mean, some do, some don't. We have a photograph in the bundle that shows, it's page 1460. 1460, this is in the core bundle, 4 volume 1460. It's the upper, figure 4.
Yes.
That's Newby raw material.
Nice.
An example of Newby raw material.
Right.
Yes, you'll see that from paragraph 20 on the left-hand page.
Yes.
Examples of chicken meat used in our process look like the following pictures at 4 and 5.
So on some you do the whole process and some you deal with it after the breasts have been removed.
Yes.
Yeah.
So it can be almost an entire chicken or whole portions of meat.
Yes.
Yeah, well, that's helpful. Thank you.
Yes, someone else said, I think Mr. Manning's evidence is at 1456, paragraph 16, his evidence on this point, where he says, 3 lines up from the bottom of the page, for poultry we sometimes use whole chickens where the slaughter was not neat enough for the whole bird to be packaged in the supermarkets. We say that where they use whole chickens, that's a poultry carcass, but they may equally use chicken bones to which meat remains, in which case they can be stage 1.
Yeah.
So but I think I was making brief submissions about the intervener's evidence. We do object in terms of timing, in terms of content, and as to whether it's relevant to the issue that you have to decide. But watching videos, Dave Benny essay, I don't object to.
But I mean, the evidence you just referred to is clearly before us. Mr. Manning.
Yes.
Oh, yes.
Indeed.
And it may well be dealt with in the evidence, but is the product, even if Newby get a whole chicken, do they separate out the breast and sell that as one product and the remainder that they recover from the carcass is a different product, or is it all dealt with together as one product?
It all goes through the Newby process.
Yes.
So the breast gets minced in effect.
Well, it's at stage 2. It would mince at stage 2. But of course, at the Newby process at stage 1 is simply removing meat from the bones.
But
Yes.
Yeah, but what, I think that's the question.
You're
Does
not-
it go on to
you're-
stage,
you're-
to
yes,
the
you're
breast
not-
go on stage 2?
Exactly. As I understand it, you're not producing minced chicken breast. You're producing minced recovered meat, some of which is chicken breast, some of which isn't.
Yes.
That right?
So it would be minced chicken. Minced
Yeah.
chicken is what
Yeah.
we'd be producing. And in terms of the evidence, because quite a certain amount of the evidence was directed towards the issue of how animals are slaughtered, and it goes to the intact muscle point, really. Mr. Bagley, for example, describes how animals are sectioned and so on and so forth. I did give you, your lordships, the reference this morning, 85404, the regulation 85404, article 5.2, MS 425. It's in the second volume of authorities, so 425. It just gives a description in a particular context about fresh meat, but because part of what Mr. Bagley's evidence was directed at was just trying to describe, trying to get his head around, well, what can be intact or not. So, and it's just there describing the way in which animals are cut down into half carcasses, quarters, and cuts produced by cutting half carcasses into 3 wholesale cuts should be carried out in slaughterhouses. So this is the process of butchering, obviously, is taking down into ever smaller portions until one reaches a saleable portion. Thank you, my lords.
Thank you very much. Well, this is obviously an important issue for those concerned with it, and we'll have to put cold towels around our heads and try to work out what the answer is. We're grateful to all counsel for their assistance. The court will adjourn.